Good afternoon. My name is John Lyons, and I would like to thank you on behalf of Stetson University College of Law and the Center for Excellence in Higher Education Law and Policy for attending today's webinar. May I stay or must I go? Higher education immigration issues for foreign students and academics in the time of COVID-19 with our host, Christian Zeller. Before we begin, I would like to provide you with a few housekeeping tips. At this point, you should be hearing my voice and seeing the introduction slide of today's PowerPoint and seeing Mr. Zeller. All attendees will remain in listen-only mode, so if you do have any questions during the webinar, please use the question and chat feature down below at the bottom of the Zoom screen. We will be moderating the question and chat box throughout the presentation, and we'll make every effort to answer them at the end of the presentation. Following today's webinar's completion, we will share both the recording and the PowerPoint. If you experience any technical difficulties whatsoever during the webinar, please feel free to reach out to our center coordinator, Kaylee Murphy. Again, thank you for your attendance today, and I will now turn it over to you, Mr. Zeller.
Thank you, John. I appreciate the kind introduction, and let's dive right in. First, the agenda, and of course, being a lawyer, there's got to be a disclaimer. We'll talk today about COVID-19 related travel restrictions, immigration related travel restrictions, and then how are you going to manage immigration to the United States based on those restrictions, and how you're going to manage immigration in the United States based on those restrictions. And of course, everything I'm about to say today is not intended to be legal advice. It is for informational purposes only. It's not so that I won't stand behind what I'm about to say today. However, immigration has been such a fluid body of law, and especially during COVID, we have had nearly daily changes. So what I'm advising today may not hold true tomorrow. So if you are planning on acting on anything that I'm about to say today, please do check back either with me or with your immigration attorney before actually taking action. Fact of the matter is that a lot of the statements today are going to be based on actual historical data and real events and life experiences. So first, let's talk about the COVID-19 related travel restrictions. I think this is extremely important because you have to distinguish what is restricted because of COVID and what is restricted because of immigration regulations. And so your inquiry should always begin whether there is a COVID-19 related travel restriction in place or whatever you want to do. Because if it is, then you got to deal with that part. And if there is not, well, then any other restriction is going to be immigration related. Now, on the COVID-19 travel related restrictions, if you come from any of these countries, the People's Republic of China, Iran, any of the 26 Schengen states, the United Kingdom, Ireland, or Brazil, and if you have been in any of these countries in the past 14 days, you cannot travel to the United States, regardless of what your status, what your visa status is. And keep in mind, it's important that you think of the geographic implications and not of your nationality background. Your nationality has absolutely nothing to do with it. It has to do where have you been in the past 14 days. And if you have been in any of those countries, you have a travel restriction or you're subject to a travel restriction to the United States. Now there's a 14-day rule and there are exceptions. Initially, travel restrictions do not apply to United States citizens, to legal permanent residents, those are persons with green cards, and their families. The good news is there are no more health screenings at the airports in the United States when you enter, regardless of where you come from. This is since 9/14. So even if you come from a Schengen country, even if you come from the People's Republics of China, once you clear the hurdle overseas, there's not going to be any more health screenings in the United States. And also, all the United States international airports have now reopened. Just a few days ago, you could only enter the United States in about 13 or 15 airports. Now all international airports have reopened for international travel. And so those travel restrictions do apply to everyone else other than the US citizens and legal permanent residents. However, there are, of course, exceptions. So what you could do, if you have been in any of the restricted countries, you could quarantine for 14 days in a country that does not have a travel restriction to the United States, and then you could come to the United States with whatever visa is in your passport. So you are certainly free to do that. For example, if you were to go to Canada, if you were to go to Mexico, any of the Caribbean islands, any country really that is not on the list that we previously looked at. However, if you plan on doing that, I encourage you to look at the CDC World Travel Map. The CDC has produced a wonderful tool by which you can determine as to what are the requirements to enter certain countries. Because obviously you want to make sure, let's say you're planning on coming in through Aruba, you want to know what are the restrictions for me as an person from X country to get into Aruba before traveling to the United States. That is the one exception that you can avail yourself of. And the second thing you can do is maybe you fall into what's called the national interest exception, NIE, and we'll discuss those in more detail. Now, first, with the immigration restrictions, I think what you need to know is that there are two presidential proclamations. The first was issued on April 22nd, and that proclamation suspended the entry of immigrants. And immigrants are all persons with green cards, people who live in the United States or want to live in the United States permanently, and who represent a risk to the US labor market during the economic recovery. Now, of course, that restriction does not apply to any person who held an immigrant visa already on that date. So if you're a potential immigrant to the United States and your immigrant visa has been issued to you on or prior April 22nd, you can come in. If your immigrant visa was not issued as of April 22nd, you're prevented from immigrating to the United States. Of course, the country welcomes healthcare workers, so healthcare workers can come in. EB-5 investors can come in. EB-5 investors are the persons, what's known as the $1 million visa. Those are people who invest significant amounts of money in the United States and create jobs. And the job creation is, of course, in the interest of economic recovery. And then, of course, spouses and children of United States citizens and members of the armed forces and their families are, of course, excluded from the first proclamation. And then there was another proclamation. And that other proclamation, the second proclamation, was issued on June 24th. And what that did, it extended the first proclamation to the end of the year, to December 31st, 2020. But more importantly, and more interesting for our discussion today, it suspended the entry of certain non-immigrants. And non-immigrants are all persons who have a visa, people who come here temporarily. And here's what happened. These are the visa categories that are included in the second presidential proclamation. The H-1B specialty occupation visa, and that's of course a very important visa for academia. Within academia, many professors and researchers hold these visas. H-2 visas, H-2B visas, which are for temporary and seasonal workers. J-1 visas, good news for academia, the J's used in academia have not been impacted. So researchers, scholars, and so on can continue to come in, but interns, trainees, teachers, camp counselors, au pairs, and summer work and travel applicants cannot. What's not as interesting for academia, of course, is L1A and L1Bs. Those are, just by way of reference, intra-company transferees where a business from outside the United States wishes to transfer an executive or specialty worker to their subsidiary, affiliate, or parent in the United States. And then all of the dependents of the above. So if we have someone with an H-1B, they're H-4, or that's meaning their children and their spouses are also excluded from entry. Now, what does this really mean? Not everyone is, of course, subject to this non-immigrant visa restriction. In order to come within the purview of the restriction, you must have been outside the United States at the date of the publication of the proclamation, and that was June 24th. And you did not have your H-1B visa, for lack of another example, issued on that date, and you are trying to apply for that H-1B visa or another visa. This is somewhat of a convoluted sentence, but what it means in plain English, just because you didn't qualify to apply for the H visa because of the proclamation, you can't apply for another visa category in order to circumvent the rules and regulations of the proclamation. Now, here's more detail on that. In order to come to the United States, if you were outside the United States, you must have had a valid H-1B, H-2, or L or J on the effective date. So if you had a valid visa on that date, you're not subject to the proclamation. You might be subject to a travel restriction, but you're not subject to the proclamation in terms of visa restrictions. Now, if you had an H visa, an L visa, or a J visa in the past, and you're outside the United States on the date of the proclamation on June 24th, and your visa was not valid on that date, then you are subject to the proclamation. You would not be able to renew or get another visa in that same classification. However, if you were outside the United States and your H, L, or J expired after the date of the proclamation, so your visa expired, let's say, on July 1st or July 15th, then you're not subject to the proclamation, and you could file for a new H visa or an extension of your existing H visa. The good news, if there are any in this convoluted mess, is that the Department of State has announced that it is not revoking any existing visa. So if you do have a valid visa, it will not be revoked just by you traveling. So let's summarize. Two types of restrictions. The first restrictions are travel restricted. Those are country specific, not based on your nationality, but based on where you have physically been in the last 14 days. And then we have immigration related restrictions, and there are two proclamations. The first one affects all immigrants, persons applying to stay in the United States permanently. And the second proclamation restricts certain non-immigrants. Those are all persons coming here temporarily, specifically persons in H-1B, H-2B, J's, and L-1A and L-1B. So your candidate, whether it's a student or whether it's a faculty member, whether it's a staff member, could fall into either one of those categories, or he or she could fall into both categories. And now let's learn on how we are going to deal with that. First, let's talk about on how you're going to manage immigration to the United States, meaning from the outside in. How am I going to get from outside to the United States? The good news is that finally our embassies and consulates are in the process of reopening, and they are commencing routine visa processing. Now, there is no steadfast rule across our Department of State here, because the consulates are obviously in all various different countries with different health and conditions. So they will open the way they see fit in order to keep their staff safe, in order to see how many people do they actually have on staff, what can they process, what can they not process. So reopening there's no uniform reopening. So wherever we apply for a visa, we will have to contact that particular post first to figure out what can we get done at that post. In other good news, if you are subject to a travel restriction for whatever reason, then there are waivers available for such travel restrictions. And if you have come within the purview of any of the visa restrictions, the good news is there are waivers available for that as well. Now that waiver, whether it's for travel or for immigration, is called a National Interest Exception Waiver, or NIE. Of course, if your candidate is working in defense, law enforcement, or diplomacy, there is no question you automatically come within the purview of the national interest exception. If your candidate is working in COVID-19 related medical care, of course, he or she comes within the purview of a national interest exception, and the same, of course, holds true for medical related research. Now, most of us, and I believe, strongly believe, that even academia come within the purview of a very different national interest exception, and that is the immediate and continued economic recovery of the United States. And if you can prove that your institution or your institution's mission, or what your institution does, what your institution teaches, the persons that are employed at your institutions, the students that study at your institution, if that as a whole takes part in the immediate and continued economic recovery of the United States, then we can get a national interest exception. And it goes without saying that academia as a whole has always and continues, of course, to contribute to the economic well-being of this country. So in order to get such a national interest exception, you have to apply for it. And the important thing when you do that is you have to be in the right mindset in order to be successful. And the mindset is as follows. You have to keep in mind that the determination whether your candidate is going to get a national interest exception is made by a consular officer at a U.S. post overseas, a person you do not know personally, a person you don't know how he or she is going to look at your application. You will be dealing with a human being, but you don't know who that person is. The next thing you have to keep in mind, and that is of utmost importance, is BAHA. And BAHA is an executive order signed by the president, I believe it was early 2017, and it stands for Buy American, Hire American. And this executive order has made its way through every aspect of immigration. If you today look at the Foreign Affairs Manual, which is the publication that consular officers use as a guide on how to issue various visas, you will find in every visa category a paragraph about Buy American, Hire American. So with every visa that a consular officer issues in this day and age, and this was even before COVID, but it is even more important now, that consular officer must, by directive of the administration, consider Buy American, Hire American. So what is it that your candidate will contribute to Buy American, Hire American? Then I always teach my clients the E2 and the EB5 argument, because it is something that ought to be made. For those of you who don't know, the E2 visa is what's called the treaty investor visa. It is set aside for persons who come here, buy a business, create some jobs, and for that they get a visa. The EB5 persons are immigrants who, that's called the $1 million visa. They invest between $900,000 and $1.8 million, and they create 10 jobs. And for that, they get a green card. Now think about that for a moment. They automatically come within the purview of the national interest exception. Well, I suggest to you that all of your institutions then come within the purview of the national interest exception, because all of your institutions have invested money, significant amount of money, way more than 900,000 to 1.9 million. And you have created more jobs than any E2 applicant or any EB5 applicant. So to make this argument, I think, is a very healthy one and a very effective one. The next argument that I would make if I'm in academia for a national interest exception for my H-1B professor candidate is the F1 argument. F1 academic students come within the purview of the national interest exception. Our administrations have found that it is in the national interest that we shall continue to accept foreign national students. Well, if we accept foreign national students, it goes without saying that we ought to accept foreign national faculty to teach foreign national students. So that argument can be made at any time, and I believe it is a successful argument. So what you have to keep in mind is how essential is your candidate's job, and how does it directly or indirectly impact economic recovery? And of course, academia, by teaching always impacts our economy. So that's the mindset I think that you have to have in order to draft a successful national interest exception overseas at the post. And here's how you're going to do it. Here's how you're going to get it. You have to show that your institution exists. I can tell you that I have filed immigration petitions and I was questioned by our government as to who IBM was. So you got to tell them who you are. Just because you think everybody knows you, that consular officer does not. So explain in detail what your institution is, where it is, and what it does. What is its mission? Describe the essentiality of your candidate's tenure. What happens if I don't bring that researcher over? What happens if we cannot bring this professor? Are we going to have to drop a class? Are we going to have some financial adverse impacts? What is this going to go to the students? I think those arguments can go on and on. You want to brag about your candidate. What are his or her contributions to the institution and directly or indirectly to the economic recovery? Of course, you want to provide everything about your candidate, supporting documentation, biographic documentation, so that that consular officer who does not know you or your candidate can have a clear picture as to who that candidate is. And when you have all of that together, here's the good news about these national interest exceptions. There is no form to be filled out. It's free form. So as lawyers, we can do whatever we think is right to make this happen. So we can bring in whatever we think is important. But the timing is something I want you to make aware of, because that is very important. If your candidate wants to enter the United States under a national interest exception, that application has to be filed within 30 days of the proposed travel. So if you want to bring someone in for the next summer semester, now to file for a national interest exception, that's going to go bad. If you want to file to bring someone in for the spring semester, it's still too early. If your spring semester starts on January 15th, well, December 15th is the earliest that you can apply for that national interest exception at the post that has the jurisdiction over your candidate's place of residence overseas. And most importantly, but not last here, prepare your candidate, because if you put together an application, your candidate needs to know what's in it. Because what you put in the application, that is what the consular officer is going to see and what he or she is going to read and what he or she is going to use to make a determination. And when your candidate comes for an interview and he or she does not know what's in that application, that's not gonna render a favorable decision. And specificity is key. Be specific. I know we're all professionals in our own right, in our own areas, and we always do things second nature because we do it every day and we do it all the time. Well, that consular officer does not know what you and I do all day and what we do good and every day and all the time. So you need to speak to them so they can understand it in detail. Be specific. So the F1 students, they are subject to travel restrictions, but they're not subject to immigration restrictions. I think that's really good news for our F1 students. So the immigration restrictions, I told you before, our F1 students come within the purview of the national interest, and I have seen now that most consulates and embassies overseas are ready and able to issue F1 visas. Not all of them, but most of them actually do. But there are still the travel restrictions. So let's say your F1 student comes from Holland. Well, if he or she comes from Holland, Holland is within the Schengen area, and the Schengen area has travel restrictions to the United States. So your student must either quarantine 14 days elsewhere in a country that does not have travel restrictions, or he or she can apply for national interest exception and will get it just by way of being an F1 student and being able to demonstrate that they have a valid I-20 and that they are within 30 days of commencing classes. Now, of course, existing visa holders can just get on a plane unless there's a travel restrictions. If you need to renew a visa, it's the same as it used to be. Of course, you require your I-20. If any of the DSOs are listening in today, you already know what you have to issue. There are really no changes at this point. And of course, if someone needs a new visa, a new student visa, I would suggest to you that the only restriction is that if your institution is providing an online program only, if there is not a hybrid model or a full in-person tuition model, then I do not see on how you're going to be able to procure a new F1 visa for that F1 student. There are other solutions, and they may or may not apply to you, but I think something be amiss if I would not at least mention this to you. Let's say your candidate is Canadian. And Canadians don't need a visa. All they need is an approval notice from USCIS, and that applies to H&J visas, the visas mostly used within academia, or if in academia you're using TN for your professor under Treaty NAFTA. That is also not required for visa issuance. It's done on an I-94. So they are excluded from the proclamation. So that's, of course, good news. But be careful with Canadians, especially if they want to come in. There was a travel restriction, and I'm quite not sure whether it's still in place. It was until, I believe it was September 21st, 2020, that the land borders were closed, but you can fly in. I have spoken to someone in Canada yesterday, and I'm being told that the land border restriction remains in place and is being viewed and evaluated every 30 days. So if you are Canadian or another national for that matter, and you want to come back in from Canada, please go to pre-flight inspection at the airport from where you fly in, because the land borders will not allow you in. Then, of course, the automatic I-94 revalidation is something that most people don't know about. It's not well known in academia, I find in my talks around the country. But it is something that now with COVID is really something you want to keep in mind. If your person doesn't have a visa but has a valid I-94, the document that allows him or her to remain in the United States, you can get an automatic I-94 revalidation by traveling to a contiguous territory. And a contiguous territory is Canada, Mexico, and some Caribbean islands. But you must have a valid I-94 at the time you leave the country. And you must apply to re-enter in that same classification. So if you have an I-94 and in an H-1B classification, and it is still good until December 15th, well, you can get on a plane tomorrow and go to Canada and then turn around and come back in, and your I-94 will be renewed in H-1B classification, as long as you can demonstrate that you have not been outside for more than 30 days, that you're applying for the same classification, that your H-1B position is still valid at your institution. So very, very interesting and helpful means on how to get around some of those visa issuance restrictions at the moment. And then, of course, you can change your status stateside. If you have a candidate in the country, let's say on a visitor's visa, and you want him to have an H-1B in academia, of course, you're not subject to the annual numerical limitations on H-1Bs. You can change his or her status. In the United States, the proclamations do not apply. Why? Well, because our president has power when it comes to entering the United States, but he has no power about immigration or on immigration in the United States. So the proclamations mean nothing for statuses in the United States. You can change your status, you can extend your status, you can apply for a new status. But beware of a preconceived intent. And for example, what that is, if you, let's say, come in on a B2 visitor's visa and 10 minutes later you decide, well, I'm going to change that to an H-1B because I have a job offer, that's what's called a preconceived intent. Because you came in on Tuesday telling the Border Patrol officer you're a visitor, and on Thursday you changed your mind and said you're going to be a researcher at a university. Preconceived intent typically goes away after 90 days. And then if you read the proclamations, there are some fraud provisions in there, and make sure you're not running afoul of those by trying to somehow circumvent the language of the regulations. The proclamations, I should say. Now, that was how we're going to get into the United States. And now let's talk for a minute on how you're going to manage immigration in the United States. Your candidate is already here. So if your candidate is on an ESTA, which is a no visa, which could be a student, which could be a professor, which could be a researcher, which could be a staff member who came to interview with you or whom you're intending to hire. And of course, we know with ESTA, you cannot change your status. You have to go back to your home country, but I'm pleased to report that the 90-day restriction on ESTA has been dealt with very favorably with Customs and Border Protection, and they have extended ESTA applicants in 30-day increments so they can stay stateside until they can actually find a flight to go home if they come from a COVID-infested country. Many people are in the country on B1s and B2s. Those are visitors and business visas. Those can, of course, be extended at any time. You have an obligation to extend those visas if they run out. And of course, you can change your status from a B1 and a B2 to an H1B, J1, or what have you. However, I think more important for us to discuss within academia is the H1B visa category, because so many professors and staff actually work here on H1Bs. And there we have to be careful. First, let me talk a bit about a furlough versus termination. Of course, you know, COVID has done a number on our economy, and not just in our business, likely in yours. You know, you may have had to furlough staff or faculty who are on H1B, and that's a dangerous thing to do. I'm an immigration lawyer and not a labor lawyer, but I will suggest to you that furloughing someone is really a term of art. You know, it's basically a termination, because if you're not working, you're not working. And especially this holds true in the H1B context, because if you furlough someone in the H1B context, the H1B term for that is you are benching that person. And you cannot bench an H1B applicant. If you do that, so if you furlough or bench an H1B applicant, you must continue to pay him or her and provide the same benefits as if they were working. Of course, you have to notify USCIS if there are any changes in employment, if it's an H1B candidate. Good news is there are some grace periods, you know, up to 60 days. You can be late to report anything or to extend the status, change the status. Another issue that we have within H1B is the work from home environment. Of course, in academia, we have found that many classes are being taught online. So the staff or faculty member may be sitting at home and teaching the class from his or her home. You want to make sure, as the employer, as the institution, you want to know where that home is. And you want to know whether that home is in the same MSA, in the same metropolitan statistical area where your candidate actually applied for. So when you filled out the LCA, the labor condition application for that H1B, you had to put in the MSA. Make sure that the work from home is happening from that same MSA, because if it does not, you have to amend the labor condition application. If you're going from full-time to part-time work, you already know if you're dealing with H1Bs, you have to amend the labor condition application. And of course, there cannot be, under any circumstance, a wage reduction. In the H1B environment, you would have to refile the entire H1B application in order to stay within the purview of the proper regulations here. Now, if our candidate is in the United States on an F1, then if the DSOs are listening in today, the March 19th guidance remains in effect. There has been a lot of talk about it, that it's going to be amended, that it's going to be changed, that it's going to be terminated, that there's going to be some new guidance. Forget about it. It's the March 19th guidance that is what governs. And I'm providing you a link here, and this is a link from Immigration and Customs Enforcement. And as an immigration lawyer, of course, I typically argue against them, and I'm on the other side of the fence. But let me just say hats off to them for providing this guidance. It is very, very good. And if you have not seen it yet, I encourage you to take a look at that. It spells out every situation that you can possibly think of for your students, and how you would have to conduct yourself as an institution, how to manage CVIS within this environment, and what have you. So really, a very, very important link for you if you have not taken a look at that yet. Now, if your candidate is in the United States, and again, in F1, you know, many of our candidates, of course, they graduate, and before they go on to their graduate degree or do something else, they want to have their OPT, their optional practical training, and a lot of them go into STEM OPT, science, technology, engineering, and math, which is, of course, a 2-year extension of the regular OPT. Now, normally, there's limited unemployment allowed when one is in OPT. In regular OPT, it's 90 days for the course of the year, and in STEM, it's 150 days during the course of the life of the STEM work authorization. But ICE has also issued guidance on that, and so has the USCIS, even though if an applicant were unemployed for more than the usually allotted and allowed time, they will not be punished for that as long as they continue to seek employment. They can, of course, work part-time, so if they originally had a full-time job, they can switch to a part-time job. There is no penalty on that. They can obviously volunteer. Any volunteer work for an OPT candidate counts towards them actually working. However, beware, this does not apply to STEM candidates. STEM candidates actually need and have to be in their training program. Volunteering for STEM candidates is not allowed. And then I'm sure you all or your students have experienced delays in the issuance of employment authorizations. There was a period where it took many, many months, and then we had a short period of time, and just at the beginning of COVID, where we got employment authorizations issued very quickly for OPT applicants, and now it has slowed down again. I'm pleased to report that the USCIS has announced if you are in OPT, whether regular OPT or STEM OPT, it doesn't matter. And if you have properly applied for your OPT to work, and if you have received the approval notice, then you are allowed to work, even though you have not received the actual EAD card, the actual employment authorization document. As long as you have the approval notice, you can go ahead and commence working. So what about the USCIS? The USCIS, that's U.S. Citizenship and Immigration Services, the agency that provides the benefits within the United States. I'm pleased to report that they have finally reopened on June 4th. They have limited traffic there. Of course, there's social distancing. I'm also very happy about the regulation that we as lawyers may appear telephonically for our clients when they are being interviewed. The appointments, of course, are hopelessly backlogged, as you can imagine, because they were shut down for over 3 months and now have to work out their backlog and have to work it out up slower than they would normally do. In other good news, there are no furloughs at this time at USCIS. I'm sure you've read in the papers that the USCIS was nearly running out of money because there weren't enough applicants paying filing fees. USCIS is not appropriated by our Congress. They finance or fund themselves by way of the filing fees that you and I pay. They have started limited biometrics appointments again, so where people have to have their fingerprints taken, they continue to get those notices. There are limited InfoPass appointments. For those of you who don't know, InfoPass appointments are appointments where one can make an appointment to go to a USCIS office to inquire about a case. In-person interviews are taking place. And the service centers, those are not the local offices. The service centers is where you send your H-1B applications, where you send your extensions of a stay or your changes of status. Those are the service centers. They have never stopped working. So they have come back with limited premium processing. So some applications can be premium processed, others cannot. Excuse me. They have waived wet signatures. So when we file applications or when you file applications, the copy of a signature is acceptable, which is, of course, very helpful during COVID. They have also recycled biometrics, meaning if a person has taken biometrics in the past, they don't have to come back for a new biometrics appointment. And they have just renewed the acceptance of their late filings. So if you have, or if you want to file an extension of stay, a change of status, if you have to answer a request for additional evidence or a notice of intent to deny and so on, you get an additional 60-day grace period beyond the time frame that the USCIS has given you originally. Now that's a discretionary time frame. If you can answer timely, please go ahead and do that. I would not want to rely on anything unless you absolutely have to. That is discretionary with the government. Excuse me. Now, what's next? Of course, lately, all we have seen was presidential proclamations and executive orders. You can go back all the way to the Obama administration, and before that, there hasn't been any immigration reforms or legislation that's been voted on. Everything has been done by way of proclamations and executive orders, and that, of course, causes lots of grief for our clients, for your institutions, for your students, for your international student body, and last but not least, for all of us immigration lawyers, because you just can't operate or continue to operate like that. What I do know, what's in the wings, the administration is currently working very hard to further assault the H-1B visa category. They want to once again define what a specialty occupation is. They want to increase the wages for H-1B workers. They want the best and the brightest, which in my opinion is just a nonsensical approach. There's already a visa for the best and the brightest. It's the O1 visa for extraordinary ability persons, and there is an immigrant category in for extraordinary individuals as well. So there's absolutely no reason to change the extra to inflict that on the H-1B category. It makes absolutely no sense. There's an attack on the H-4s. Those are spouses and children of H-1B visa holders, and the attack is really on the employment authorizations for certain H-4s. Those will likely go away. The president has been talking about eliminating OPT. Personally, I think this is just a lot of noise. I just don't see that happening. DACA comes and goes from the Supreme Court, makes absolutely no sense. And DACA is, of course, a function of Mr. Obama's executive order, and then gets changed with another executive order, and then works its way from the lowest court to our highest court and back down again the ladder and back up. So the whole thing makes no sense. TPS, temporary protected status, is now being eliminated by the administration step by step and country by country. We have temporary protected status for individuals, from Sudan, from Haiti, from Honduras, and some other countries. Unfortunately, the Ninth Circuit has just ruled a couple of days ago that the president can do that, which brings me to our separation of powers. I don't know where they have gone. This is, of course, not a political discussion, but I will certainly say that our Congress is absolutely useless, or has proven useless in this quest for proper immigration regulations. By our Constitution, it is the Congress's job to legislate on immigration. I have not seen any meaningful immigration legislation since 1986. All we have seen since then have been restrictions and proclamations, executive orders, and regulations that have been thrown at us without the proper rulemaking, and so on and so on. Further on the separation of powers, both parties, the Democrats as well as the Republicans, have begun to utilize our Supreme Court to advance their agenda. It is, of course, not our Supreme Court's job to legislate in immigration, and hopefully this Congress will find its mission again and go back to what they are charged of doing, and that is to legislate. We know that this administration has spoken about merit-based immigration for the better part of 4 years now. Nothing has happened within that. proposal. It is my personal prediction that nothing will happen there. Merit-based immigration is a failure in the countries where it has been tried, such as Canada, Australia, and the United Kingdom. And our immigration system is not based on merit-based immigration. And if one were to dissect it as a lawyer, we already have merit-based immigration within, we have the family-based immigration, and then we have employment-based immigration, and all of our employment-based immigration is merit-based, because as you well know, if you want to bring someone in H-1B, they have to have a degree. If you want to bring someone in O-1, they have to be extraordinary, and you can go through the entire visa alphabet and name any visa, and if it is employment related, it's based on the merits of the applicant and the company wanting to bring them in to make it happen. The elections, of course, typically introduce a lame duck session, so I don't think that anything will happen within immigration. I don't think that there will be any changes or anything significant in the next few months. We always hear things, whether there will be immigration reform or whether there will not be immigration reform. We have listened to proposals under the first President Bush. We have listened to proposals under the second President Bush. We have listened to proposals under Mr. Obama. We have listened to proposals under Mr. Trump's administration, and nothing has happened. And personally, I think that this approach of comprehensive immigration reform is a Gordian knot that cannot be untangled if you have a Congress that is so divided. And I personally think that the only way to resolve at least some of our immigration problems is to go about it piecemeal, do it a step at a time, and hopefully find consensus here and there, maybe on the things you see on top of this slide, on the H-1Bs, the EADs, OPTs, DACA, and TPS. That would be a good start. And that brings me to the end of my talk. And with that, I thank you for listening and turn it back over to John, and I'll be happy to answer any of your questions if you do have any.
Well, Mr. Zeller, I do have a few questions regarding what you've just discussed in terms of what we can expect in the future. Given, as you described, one, Congress has demonstrated unwillingness to address the issue and punt off to the next session. And outside of any court decisions, I wonder, can we expect just further policy via executive fiat in regards to how higher education can expect immigration policy to unfold?
Thank you for that question, John. I think that academia is really in a good place, if one can say that. Given all the circumstances, because the talk about attacking OPT, that's just not going to happen. I can just tell you that's just talk. And if we look at all the other issues, look at the F1s actually being, coming within the purview of the national interest exception. So there is a consensus. Yes, we want foreign national students. If there were really a tightening of the H-1B, I do not think that this would in any way adversely affect academia. And I say this because first, academia is exempt from the annual numerical limitation on H-1Bs. And if the specialty occupation description as to what is a specialty occupation were to be tightened, anyone in academia would be the standard and not be grappling to actually meet that expectation. I think that academia would be up here. It'll be for someone else to fight to actually meet that new description. So I do not see anything negative for academia at this point. And also, if you look at ICE on how lenient they have been with the online studying because of COVID, with the hybrid models, and now having extended this model until the end of the year, I think academia is in a good place overall compared to all the other immigration restrictions.
Well, that's certainly encouraging. I guess a follow-up question then is, what what is, as in your expert opinion, what have you seen to be the easiest avoidable mistake that institutions do make in regard to the immigration status of their staff or their students?
Two things: planning. An immigration application can be filed 180 days prior to its expiration. Get away from the last minute issue, because if you have an opportunity to extend something today and you're eligible, go ahead and do it. So plan the timing. And secondly, I will say, be very, very specific when you apply. Everyone listening in today who's a DSO who has ever filed any type of immigration application lately knows that you're gonna get a request for additional evidence. I will suggest to you, if Elon Musk were to file an application today as an individual of extraordinary ability to come to the United States to build Tesla cars, he'll get a request for additional evidence. So, you gotta be specific on what your candidate does, because it's this request for additional evidence who has caused so many of us, including everyone in academia, all this grief, where you want to explain as to why my nuclear physicist is working in a specialty occupation.
Gotcha. Okay. Well, I guess a final question before we wrap things up is, thinking about smaller universities who might not have a robust general counsel's office, might just be on retainer single attorney, somebody who doesn't have expertise in immigration law. What steps outside of the guidance document that you referred to earlier can they do to make sure that they're covering all the bases they need to in order to protect those students and their faculty?
Well, John, obviously, my answer is going to be maybe perceived as biased on that, being an immigration attorney myself. But the attorneys or general counsel at a smaller institution typically does reach out to an immigration attorney when it gets a bit dicey. Maybe the advice is reach out a little sooner. Establish a relationship with an immigration attorney, and if it's just for a few questions, because right now things are so volatile, they are so fluid, and they change so quickly that general counsel may not be aware of it when they're in their own work environment. So just having that relationship with an immigration attorney who deals with those issues on a daily basis is probably the best thing to do.
Well, before we sign off, Mr. Zeller, I have to thank you on behalf of Stetson University's College of Law and the Center for Excellence in Higher Education Law and Policy, and on behalf of all the attendees today. Thank you. This has been quite the enlightening experience on something that is, heavily important, but also just kind of lost in the weeds of the overall dialogue of COVID-19 and higher education. So again, thank you.
Thank you, John. I appreciate the accolades, and it's always great to be back on campus, albeit virtually this time.
Well, I'm glad we could afford you the opportunity. Just a quick bit of housekeeping before we wrap things up. You will receive a link to the PowerPoint and recording, a link with copies of the recording and the PowerPoint. You will also receive CLE information once it is made available to us. Also, for those viewers of today's webinar who viewed this as a recording, if you do have any questions about today's webinar, please don't hesitate to email the center, and we will forward any questions you may have over to Mr. Zeller. Additionally, if you wish to learn more about the center or have any questions about upcoming webinars, I encourage you to visit our website or reach out to our staff. Finally, again, thank you, Mr. Zeller, for taking the time to speak with us today. And again, to all of you for joining us. Without your attendance, these webinars would not be possible. So with that, I wish you well, and we hope to see you again soon.
Thanks, John. Good day.